What's up, everybody? Welcome back to another episode of the Lawyer You Know podcast. And this week, we're talking to somebody we've done a podcast with a long time ago, and he just posted on YouTube earlier this year that he is back making videos all the time. He's not retired from life or burned out on life, as he told me before we started, but we'll get into why he's back making content, why he took a break, I'm sure, throughout this episode. But the main reason I wanted to have him on is he is the main lawyer in a big lawsuit coming down the pipe that's affecting a lot of creators and maybe affecting a lot of you guys as consumers of, using creator discount codes and things like that. And that's the Honey lawsuit. I don't really know a ton about it. I've seen some videos on it, specifically his. So I'm bringing on attorney Tom, who is a real lawyer.
I'm suing Honey right now. My name is Tom Kirker.
He does some of what I do, which is personal injury, wrongful death, catastrophic injury work. But he also does this other area of law that this lawsuit would fall into. So, Tom, thanks so much for joining me today.
Hey, Peter. Good to be here.
Yeah, man. So I know when we first talked a couple years ago, I know your dad has a law firm that you're a partner in, and you also had your own firm. Some stuff has changed with that. So I want you to tell us a little bit about that and this area of law that this I'm not going to call it a new law firm, but this merged law firm is focusing on.
Yeah, sure. So I guess the short story of it is 6 years ago when I became a lawyer, my father, who is a lawyer, would not hire me. So he wanted me to go out on my own or go work for somebody. So that's what I did. I started my own law firm. I had quite a lot of success, call it luck or whatever. I stumbled upon some really, really big cases right away, did some really good work. Within 2 years or so, my dad offered me to come work for him. But by that point, the math didn't quite work because I had my own law firm with a few employees at the time. So I did that for about 6 years, primarily focused on single event catastrophic injury cases. Then about a year, actually for the last probably 2 years, I have been dabbling in other plaintiffs' work, class action work, privacy litigation, things like that. And an opportunity came up with a friend who I am doing some cases with. And we just got to talking and we said, hey, screw this. We should just merge our firms and create a big firm. So now I still have a silo to do single event cases, and that is my dad's firm where I'm a partner at. But now I think we have 12 lawyers right now. No, maybe 11 lawyers. 11 lawyer staff of maybe 15 already. And it is a firm dedicated towards class action, consumer cases, privacy, antitrust, basically all plaintiffs' work that is not personal injury. But we don't bill by the hour. It's all true plaintiff stuff, but it's just not PI. So it was just a way for me to diversify what I can practice in because I have two very well-run machines behind me. And I don't claim to be some savant of law. I just have a lot of great team members who enable me to practice in all areas.
And it's a very different world than, like you call it, single event catastrophic injury work, where, you focus in on a lot of the damages, a lot of one specific point in time and proving what it is that somebody did wrong and breaching their duty. And this new area, I'm going to call it a new area from my perspective, just as we talk about it, can be a lot more complex, right? And I don't mean any offense to single event injury work. That's what I do. But this can be a lot more complex, and there's a lot of different rules and statutes and things that you have to fit in, a lot of investigation on the front end to try and build up a case and determine what happened and how many people are involved and whether or not the defendant is, somebody that's going to be able to pay big damages, because a lot of these cases become huge on the damages portion. And then they have a lot of complex issues on the back end, right? Just because you get some kind of big settlement or big check or fund created, then you got to figure out who's going to get paid and how much and those types of things. And you got to get court approval on a lot of it. I have not even dabbled, been involved in a couple, mostly referred them out and kind of hung around to help with client management and talking to the clients that I brought in. But this Honey lawsuit sounds like something that fits more in obviously that second bucket. Why don't you tell us how you got involved in that, how you heard about that, and how it fits into this new law firm that you've merged?
Sure. So a YouTube journalist by the name of Megalag created an expose about what Honey is doing.
Now, you've probably heard about Honey. You know, the browser extension that saves you money.
Do you have Honey installed?
What's Honey?
Oh, no.
Honey.
Honey is a free browser extension.
Free browser extension.
Free browser extension.
Free browser extension.
That automatically applies coupon codes when you check out online.
Free money, basically.
It's literally free money.
It doesn't make sense to not be using this.
So what's the catch?
There is no catch.
Join Honey. Join Honey.
Join Honey.
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 Honey. Honey.
Honey.
Honey.
Honey.
Honey.
Honey.
Honey.
Join Honey.
Yeah, I hate to break it to you, but your favorite influencers sold you a lie. Honey is a scam, and the majority of claims promoted by those influencers aren't even remotely true. But it gets worse. Honey hasn't just been scamming you, the consumer, they've also been stealing money from influencers, including the very ones they paid to promote their product. And I'm not just talking about a few bucks here. I believe the scam has likely cost content creators millions of dollars.
And I watched it and instantly sent a text message to my team saying everybody needs to watch this. This is a huge deal. We need to jump on this. Simultaneously, Devin Stone, Legal Eagle, who's a friend of mine, watched the video. And within 30 minutes of us watching the videos of each other, we were texting about how this is not right and we should look at if there is a potential legal angle that we could take.
Yeah, and you have been doing content for a long time. I think probably from right when you started, right when you became a lawyer. I don't know, maybe even did some in law school. And we connected a few years ago, and I know you had a huge TikTok channel, big YouTube channel. You took a little break from content. You had a big year in your life. You had your first child, which is amazing. Congratulations on that. You won what do they call it at your club?
Just the club championship.
Okay.
Yeah, it was a big personal.
It's huge. I wish
yeah.
I don't even have it on my like dream or goal list because I know I'll never get there. So but like that's amazing. Like that's when I heard that I was like, that's so cool.
Yeah, I don't know how interested the audience will be about golf, but I love golf. To my right, I have a golf simulator in my office. I tell people I attempted to play college golf. I was good enough to get. There it is. We're talking now.
We'll have to link up and do something online.
Yeah, I got, I've played in a lot of events. I got to the final stage of PGA Tour Canada Q School and then came in dead last.
You got to be a stick to get there.
Yeah, I tell people I was good enough to get cut multiple times by my college golf team. So I got, was on the team, got cut. They let me stick around, and then they cut me again. So I wasn't great, but I love playing. It's a huge passion of mine. But I don't want to.
That's awesome, and that is awesome, and that's kind of how your channel popped up again on my page. Your I'm back video to making a lot more content, and then shortly after was this honey video and some misconceptions people had about it. I had not heard about it since I watched your video. The algorithm has hit and placed a bunch of other videos on my main homepage, but I really want to dig into it with you because it is something that kind of hits the world of legal YouTube and consumers in this day and age of, ads and ad reads and sponsors that do a lot to help different creators, different channels. They give discount codes, and it's a benefit to the viewers, watchers, listeners to have these discount codes. Then it benefits the creator on the back end. So where does Honey become involved? And you can give us kind of a brief overview, big picture look at what this case is about.
The biggest picture I can paint is the creator economy runs on sponsorships. Okay. Creators need to make money. AdSense oftentimes doesn't fill that need, the amount of money they need to make. So they need to take sponsorships. These sponsorships are either in the form of affiliate links, where the creator maybe isn't getting a payment up front, but they're getting a commission of every sale, or via coupon codes, where maybe it's you're selling some product. I don't know if you take sponsorships, Peter, but
yeah.
Okay, what is a common sponsor that you have, and do they have a code lawyer 10 or lawyer?
Yeah, like HelloFresh, LYK 10.
Right. So HelloFresh, lawyer 10, right? Mm-hmm. And the consumer gets 10% off or whatever. What we allege is happening is the Honey browser, at the last possible minute, right before the checkout occurs, affirmatively switches out the affiliate link or the coupon code with their own attribution. What that does is take away the creator's data and or their commission that they would be entitled to. In other words, on the affiliate commission example, if I want to buy a camera and you have an affiliate link to the camera that you use. I click on it. I'm on my Amazon page. I'm about to buy the camera. You might make $30 from that affiliate link because cameras are expensive and you're going to get your cut. Well, if I run a Honey price checker for a coupon, that action switches the attribution from the creator to Honey. And it doesn't matter if Honey is able to provide, or let me be clear, we believe that
Allegations, all allegations. Yeah,
allegedly,
yeah.
we believe that it doesn't matter whether or not Honey is actually able to provide any value. They are taking that link regardless. And the whole point of an affiliate link is to get people to the product. So the creators are doing all of the hard work getting people to the checkout. And then at the last possible minute, under the ruse of, we believe, the ruse of a coupon check that oftentimes doesn't work or provide any value, Honey is coming in and receiving a windfall for the attribution that should go to the creator.
So is Honey a plugin? Is it a site like Google where it's always on your browser? What is Honey?
Honey is a browser extension.
So basically, it's just kind of always there.
Correct.
So when you go on to HelloFresh, you type in LYK, Honey automatically is going to check, well, maybe Attorney Tom has a better % off for you. That's what I'm assuming that's what they're selling.
Correct.
That we're going to search around to all these creators, see what the best coupon code is. Oh, hey, look, we found one that's 10% off, even though the one you put in was 10% off, but this is the Honey discount code. So now Honey's getting credit for it, a kickback, whatever it may be,
Correct.
whatever Honey gets.
And in that example, if I'm now the HelloFresh representative and I'm looking at my data for you and I say, hey, Peter, I paid you $1,000 to promote HelloFresh.
Yeah.
I expect 10 conversions for $1,000. Well, you might have actually gotten 15 conversions, but on my paper, I'm only seeing 7 because 8 of your consumers had the Honey browser extension and they swapped it out, meaning I don't know what your attribution actually is. So I'm either not going to offer you a renewal or offer you renewal for a cheaper price, or at the very least, if I do renew you, it's not going to be for what the fair market value of your promotion is worth.
And I would assume this stuff is all tracked, right? It's all electronic. Is it pretty easily tracked? Like, what is your investigation showing about how you guys think you can prove this?
Yeah. So we haven't conducted any discovery. So without seeing the internal code of Honey, we believe that all of this data is tracked and they know part of the journey of the affiliate link, how many attributions were attached to it should be tracked. Again, that's what we are hoping for, right? To create a trail, that there's a trail. But again, with a case being just filed, we just have what we believe is technically feasible and possible looking at the code. I mean, we have experts who have, consulted with us and, told us how it works without getting into details. But yes, we believe that this is a very sophisticated extension with hundreds of thousands of hours of engineering time put into it. Very data driven. They were purchased by PayPal for $4 billion. The reason why they were purchased is because it is a very sophisticated tool that tracks tons of data. So we believe that all of that will be traceable.
So yeah, I would think it would have to be traceable, and not just traceable, but I would assume, and I'm not deep in the world of sponsors, so I don't really know how all that works. Like, I don't know what they even expect of me, really. They just tell me like, hey, if you like it, talk about it like this for 60 seconds or whatever.
Sure.
I don't really know how all the conversions and stuff work, but the people that kind of work with me on that and go and pitch stuff and bring in sponsors and whatever it may be, they, I believe, are pitching something to the sponsors. So I would think that Honey has the data that they're writing emails to, HelloFresh or Rocket Money or whatever it is, and saying, hey, we had 27 conversions, last month on this. So therefore you should give us more money. And they're using their data that's coming from when people are using them at checkout to then go drive up prices for sponsors to use them, I would assume as well, because I'm remembering back to whether it's MKB or some of these huge YouTube channels. I think, was it even Mr. Beast was advertising Honey? Is that a thing?
Yeah, sure. I mean, it's entirely possible. I know that through the course of uncovering all of this data, we found instances where honey is potentially going to the back end merchants and saying, "Hey, it's better to work with us than against us. And if you work with us, give us a 5%." I'm making up an
Yeah,
example.
yeah, yeah.
"Hey, I have a 20% coupon code out in the ethos, but I don't want everybody with honey being able to get 20% off. So I'm going to give you this 5% code. So honey, all users who use honey receive this 5% code rather than the 20% code, even though honey has marketing, we believe, that says we will find you the best code on the internet no matter what." So it's kind of speaking out of both sides of the mouth. On one side, they're telling consumers, "Hey, you should get on this platform because we'll find you the best discount code." On the other, maybe that's not the case because they've struck a deal with the back end merchant. They certainly
Well,
have affiliate deals with whoever, Amazon, the big affiliate players, where if their extension is used, then they get their commission. I don't know, again, without having conducted any discovery, I don't know if they get any special priority or special treatment or a higher percentage for the amount of volume that they've been bringing in. But the crux of this case is the way they're bringing in so much attribution volume is because at the last possible minute, right before checkout, their browser is switching out the proper affiliate code regardless of whether it provides any value or not.
so the creators, obviously, from your perspective, I assume, and I want to get into who your clients are at this point and where you expect this may go. But so the way you've explained it can obviously be bad for creators, people on the internet, people making money through these affiliate links. But also, it sounds like it can screw the consumer, which is, the listener, the watcher that goes and puts in a coupon code and they think they're going to get a better one by using honey, but instead there is a better one out there that they're not getting because they're using honey because of whatever honey's worked out. Or even you can see scenarios where, lawyer, gets you 10% off. Honey finds one that somebody else gets you 20, but honey says, well, we'll just do 5. And then they get that extra 5
Yeah.
and the company makes more money and everybody makes more money. And it screws the consumer at the end because they don't get the best discount code, even though they have everything in place that should get them whatever the best discount code is.
Yes. There are a lot of potential angles to this, but we believe, subject to being wrong and changing my opinion and doing more research, that
Mhm.
consumers likely have an arbitration agreement and class action waiver. So our case is not on behalf of consumers, it's on behalf of content creators and businesses who rely on affiliate links.
Who have no contract, they're not in privity at all with honey.
Correct.
We may not even know honey exists, right? I mean,
Correct.
that's a possible thing. So we'll talk for a second because there are some people that watch this channel and listen to this podcast that enjoy getting into the weeds of some of the legalities of this. So the difference between that is if you don't have a contract with honey and you may not know they exist and they are doing something to hurt your business or taking part of your profits, either by fraud, by, trickery, by coming in and false advertisement and fraudulently misrepresenting what they do, and it hurts you, then you can, sue them. And if there's enough of you and you have a common enough case, common enough cause of action, I'll let you explain the class action stuff a little bit more. But on the other side, if you are somebody that is in privity of contracts, you have some kind of contractual agreement with honey, like you sign up, they are your web browser extension, like you explained at the beginning, you probably click a button that says, I agree here or accept, and then you move on and they plug in and you think you're saving money. But in reality, you've just waived some of your rights. And at that point, you can't go to court. You can't join a class. You can't hire a lawyer like Tom or his firm because, that you can, but not to do the big class action lawsuit, which has obviously a lot more leverage, a lot more ability to be far reaching in the litigation. Instead, you have to go down a different route, which is arbitration, which can be much quicker and simpler, especially for a defendant. That might limit what you can get in discovery. It may, usually arbitration awards, it's not a one-to-one, but usually arbitration awards have a tendency of being lower than what you can get in court, what you can get at trial in those cases, which is why a lot of big companies and defendants favor arbitration agreements versus actually being sued in court, being part of a class action. So it's a negative element potentially for some of the consumers that were actually using the product. I'm going to ask you if you agree with that, and then explain kind of what you're doing and how you would make up a class in this case.
Yeah. So first, your assessment of consumers is right. It's not that they don't have rights; it's that those rights have to go through arbitration. Now, there's a saying that gun kicks as hard as it shoots,
Mm-hmm.
and there is a legal style of cases called mass arbitration. What that means is if you have thousands of wronged consumers that are willing to sign up, you can file these individual cases, and the company who is the one compelling arbitration then has to go fight thousands of individual cases in arbitration, and probably has to pay lots of money, not only in their lawyers to defend it, but in arbitration costs as well. Because there's a lot of case law that says if you force a consumer to go to arbitration, the entity has to pay for the consumer to go to arbitration. And just for reference, these arbitrations can cost $30,000 to $60,000, whereas filing a lawsuit costs $300, right? So if you go out and line up thousands of individuals, consumers, but to be clear, as of right now, we're not doing that. I'm just
Right.
pointing out, that's how the legal system works. And
Mhm.
sometimes lawyers do pursue a mass arbitration way to settle these types of cases. But again, we're not focused on the consumer. We are focused on content creators and business owners who might not have ever known Honey existed. So there's no privity of contract, there's no class action waiver. And the reason why the vehicle for class actions exist is because it is the most efficient way to right a wrong that is potentially the size of what we're dealing with. Because rather than filing, I'm making up an example. Let's just say creator A is a smaller creator. She has maybe a few thousand followers. She's growing. Her affiliate commission, her damage model might only be $100. Okay. But for the Honey browser extension, she would have $100 more in her pocket. Well, nobody's going to go hire a lawyer for $900, $1,200, $1,500 an hour to go sue over $100. Or no lawyer's going to take it on a contingency fee to just recover $100, so they get 30% of $100, so $30. It is uneconomical.
But that $100 makes a difference to her.
That $100 makes a difference to her, but also that $100 makes a difference to the company. Because
Mhm.
if you didn't have the class action vehicle, what would happen is companies would just scam people for an amount of money that is meaningful to them in the aggregate, but not economically feasible to pursue.
Exactly.
So you would just go from place to place. You would lose $5 at the gas station because the gas pump would start running before the gas actually starts going into your tank. Then you'd go across town and you'd lose $10 here and $100 here, and everything would add up. There's a great book called The Conservative Case for Class Actions. And every time you bring up class actions, you see the comments, ambulance chaser, the lawyers are the ones who are going to make all the money, blah, blah, blah. It's written by a guy who clerked, I think, for Scalia. He was the number one graduate in his class from Harvard Law School. He's a professor at Vanderbilt. He is a Federalist Society speaker, liaison. And the thesis of it is how litigious an economy is directly correlated with how prosperous it is. That's because companies know if they put out bad products, there will be lawyers who can come after them and right their wrong.
Right the wrongs, right.
Right.
Yeah.
So
Yeah, and we're gonna have those people here, like we always do. And a lot of people that always watch, always comment, always involved, came into this channel and this kind of sphere and with that thinking, and I've learned a lot about how the justice system works and how that's why we have seatbelts, that's why we have warning labels on food and medication and stuff. It's all because some annoying ambulance chasing lawyer decided to file a lawsuit to protect the rest of society. Basically, it's like,
Right.
listen, we're not heroes. We don't need a cape.
Right.
And yes, lawyers make a lot of money,
Yes.
but they do fight for a lot of good in a lot of situations. There are bad lawyers. There are bad lawyers that do personal injury, bad lawyers that do insurance defense, bad lawyers that prosecute cases, bad lawyers that are criminal defense attorneys, bad lawyers that become judges. We get it. But there is a place in society for a good personal injury lawyer, plaintiff's lawyer, like you'll call it, because of all the different facets in which you can practice on the plaintiff side. So I'm glad we're having this conversation because I do think it's important to point out.
So all of that is to say, we are attempting, and you mentioned at the very beginning of this podcast how there might be some procedural complexities that maybe don't exist in single event cases. We are seeking class representation, and it's not just me. At the very first thing you said, Attorney Tom, the main lawyer in charge of this litigation. I'm not the main lawyer in charge.
That's how I see it.
My firm, we were the first law firm to file this case. But since that time, and this is another detail of how class actions work, other law firms have filed into this case. Some of the most prestigious law firms in the entire country.
And that's good.
Yeah, it's good. What will happen is likely, I never hold the court to making a decision, but generally what happens is the plaintiff's lawyers will consolidate. The court will appoint a leadership team devised of, 3 to 5 law firms. They'll say, okay, you guys work together. This is your case. We realistically can't have 7 different class actions about the same thing at the same time. So we're meshing it all into one and we're going forward. So none of that's determined yet. That will likely happen soon, but we are asking the court to grant class certification, or we will. We haven't filed the class certification yet. Again, these are boring legal technicalities. We are seeking to represent the entire class of individuals who are content creators or business owners who receive money as a form of business income from affiliate links and sponsorships that might have been incorrectly attributed to Honey.
Yeah, and I think that's, in a lot of times, different class action lawsuits, you can kind of keep your lawyer and follow along with the class. You can sign up with this law firm. You can get a referral fee by sending to the law firm that's running the ball. And from my perspective, you're the one that I've seen bring it to light. I know you have, multiple clients going into it. Who the heck knows who's going to end up being the lead firm or, multiple lead firms when the time comes. But I think you're going to be intimately involved in this probably throughout the process based on how it's begun. How did you find creators that were affected by this? Did they know they were affected by this? Are you assuming they were affected by this?
Well, once this story came out, everybody knew. You do self-reflection and you say, "Wow, there's no way this has not affected me." And the creators that we have, that we are friends with, that they very easily knew or have a reason to believe that with a high degree of probability that they have been negatively affected by Honey.
Right. And that's something that, again, from their perspective, from Honey's perspective, some of their arguments are probably going to be, well, even if we did take the sale, we did find a better deal for the person, right? There's probably going to be some scenarios where they could have got 10%, Honey got them 15%, whether or not they shaved off the top, you'll figure that out. But theoretically, they provided the service that they promised. So even though your creator lost money, Honey didn't do anything wrong. They did what they said they were going to do, because from the consumer's perspective, just like we go into any store, price matching guarantees, we show them what it is on Amazon and, they'll go ahead and match that price, whatever, because the consumer wins, which is, good for everybody.
And that's why I agree. And there's no doubt that PayPal, and I actually know who the lawyers are because they've reached out, but
that was going to be one of my future questions.
Yeah, it's a lot of people online say, "Oh, this is a slam dunk case. This is an easy case." No, it's not.
Wish that existed.
It's not. PayPal is going to have great lawyers.
Mm-hmm.
Presumably, they're going to fight tooth and nail, but it's a case that we believe in. I mean, at the foundation, I'm not suggesting that PayPal doesn't have defenses. They are going to raise, I'm sure, a bunch of defenses. But at the end of the day, we believe that the Honey browser extension is unjustly enriching PayPal at the cost of creators.
What are some of the causes of action you guys have pled?
Yeah, so I believe in the first complaint, the first amended complaint that we filed, which again will likely change once leadership gets established and there's one amended complaint. I believe there are 5 causes of action. There is intentional interference with prospective economic relations, intentional interference with contractual relations, unjust enrichment, violation of California's unfair competition law, the UCL. Side note on that, if that claim goes forward, it would likely be a California subclass, meaning it would only be relevant only relevant to plaintiffs in California, class members in California. Unjust enrichment, And am I circling? I said unjust enrichment,
Yeah, I think you
UCL,
said
IIU.
4, but
Um,
I
what
think
are,
we get the point. If the next one
yeah,
comes to you, you can feel free to let me know. But yeah,
this is
so
embarrassing.
it's not your only case, so I get it. I
No,
get it.
I
You
let
gotta
me.
find it? You wanna take a
Oh,
second?
I'm gonna find it. Yeah.
Okay, all right. Well, you'll find it and tell us. But so what I'm listening to and what I'm hearing is fully intentional. That this was all intentional conduct, and this was purposeful. They kind of knew what they were doing. They wanted to do it. It was probably part of the business plan, and it wasn't like they accidentally created some program that was shaving stuff off the top. Or do you not know? Could it
No,
be
that's right. That's what we are alleging.
right?
The way we look at it is you have to design code to affirmatively take out the old code.
Mm-hmm.
So they are intentionally replacing the attribution of the affiliate code or the coupon code with their own. That act is intentional. So that and things just don't happen. They had to intentionally design the system, we believe, so it did that.
Right, right. And that's what I was going to ask, because it is possible in the world of tech that something happens accidentally. Now, usually when somebody brings it to your attention, you fix it. You don't just keep rolling with it, especially if you're making a ton of money on it. Um, but when
But
you
the,
said
the,
you've talked to their lawyers, if there's anything you can share, if not, no big deal, because I get it. There may be something that need to stay
yeah,
private, but
there's not there. I can't share anything like that. The only reason why I brought that up
sure.
is PayPal. If you watch my first video on it, I said
Mhm.
I'm confident that PayPal is going to hire excellent lawyers
Right.
to advocate for their position. And I was just simply stating that is true.
Yeah. It's not just going to be the Geico in-house counsel. No, nothing against Geico in-house counsel, but they're going to be people specifically sought out that focus on this type of litigation, this type of defense. It's probably all they do. And they're going to be focused on fighting this case, especially because the numbers can get big. Like you said, there could be a creator that lost $100. There could be creators that literally lost millions of dollars over this. Because some of the ad deals are so huge for some of these huge channels and these huge creators that they make their living off it. They build their empire off it. They pay all of their employees off of it. So it is incredibly important. One of the reasons I want to bring up the defense attorneys and the defense, not necessarily to get into the conversations, but when you have a class action, very rarely is it a case like, I don't know if you followed the P. Diddy, Jay-Z case and the Tony Busby in your area, right? Ish.
Yeah,
Um,
yeah.
and so demand letters and potentially settling cases before they get to court. That's very different in class action litigation. This isn't a case where the defense attorney is really going to be able to call you before you file and settle all the cases, because there's so many people out there that are affected and some people you don't even know about yet.
That's right. And generally speaking, again, not to get into the legal minutia, but generally speaking, philosophically, I hardly ever send demand letters, regardless of whether it's a first party case or single event case or a class action. I personally don't believe in them. I
Okay.
think for the most part, they are a waste of time. Defendants don't take them seriously, or if they do, they want to settle for pennies on the dollar. It is far more effective to get a case on file. But in the context of a class action, yes, you are correct. As seeking, and regardless of what, and this has nothing to do with PayPal in general, or this case in general, I'm just talking about
Mm-hmm.
in general. In order for you to get a settlement, even if a corporation admits to no wrongdoing, quote unquote, the act of the settlement is a de facto admission. And so,
That's how we see it on our side, at least.
right, if I were a large corporation, you really don't want to settle these cases individually, especially with not a lawsuit, because they'll just keep coming forever and ever and
Mhm.
ever and ever and ever.
And once Tom settles one and somebody else calls Tom
Right.
knows
Uh,
they're going to pay on it. So, now it's like, you just keep having kind of the revolving door as well.
Well, again, this goes to the efficiency of class actions, and the reason why they're very misunderstood, and actually a great vehicle for the economy is large sophisticated corporations. And I'm not saying PayPal is thinking this here. Again, just to be clear, if a large sophisticated corporation knows that they have committed a tort at a mass scale, they're often wanting to be sued in a class action to buy peace. Because if a class gets certified and it gets resolved, then that bars any potential plaintiff so long as they fix their business practices and they're not going back to their old shenanigans. That's actually some cases that we have that has happened. But it buys peace for them because they know that, hey, instead of having to deal with 10,000 separate lawsuits, I can deal with one lawsuit and win or lose. I'm at least only dealing with one lawsuit.
Yeah,
right?
they can bring it and they can build it into their budget for the next 5 years or whatever to pay for it and make it all
Right.
work for to pay all those people, as opposed to an unknown amount of money for an unknown amount of time. Once the lawsuits are filed, they could last forever.
Right. I mean, yeah. I mean, we do a lot of data breach and privacy litigation, class action. So that's like
I've
when you
done
get
one of those, and it was
yeah, you get a letter in the mail saying your social security card
yeah.
was leaked by a doctor's hospital or whatever.
Mhm.
Oftentimes the general counsel, they know what's coming. They're like, okay, good.
Oh yeah,
I'm
they
somewhat
sent the letter.
right. I'm somewhat relieved that you have reached out because I knew it was coming. I just didn't know when.
Hmm.
And this is the appropriate vehicle to hopefully settle all of these claims. Right. I'm not saying that
No, I
PayPal is
get what you're saying.
endorsing
Sure.
it, but I'm just saying that when you have a potential scenario with maybe hundreds of thousands of people affected by this, there's a strong argument we can make, which we will present to the court, that a class action is the appropriate vehicle to pursue forward. Because if a class is not certified for whatever reason, you'll likely see a bunch of individual cases proceed,
Yeah,
right?
yeah,
Or you get the situation where a creator has only lost $100 and there's no economic way forward for her because nobody's going to sue over $100.
right, right. Yeah, unless they want to waste a lot of money. Yeah, and
Yeah.
I think I agree, and I do think that the whole system of class action lawsuits can be good for judicial economy, even though they seem so complex and difficult to understand at times, and there's so many rules and hoops to jump through. There's a method to the madness. I would argue demand letters also serve a purpose for judicial economy, and I think they can be helpful in some cases, and even some big cases where there are caps or issues in different jurisdictions where sometimes you can come to an agreement that's even more than the cap before you get into litigation. And, we've had that happen at times. And the way I see it and the way I kind of do it is I give them a chance to come to the table with a good faith basis, especially because most clients, and I guess it depends on the circumstance, right? It depends on
Sure,
how
of
big,
course,
how
of
bad it
course.
is. But
Ne-
if they don't want to go to court, you try to resolve it without court. And if you can't, you can't.
a-
But
Absolutely.
I think as far as classes go, one question people have is, how do you deal with all these different creators saying, well, I want $1 million. I want $100. Does everybody get $1,000? How do you determine it? How do you play it to the court?
Yeah.
Let's say you end up with a successful fund from Honey and from PayPal. What happens?
Yeah, sure. So, what would happen is first and foremost, not all creators, just because a creator's in the class, doesn't necessarily mean that they are affirmatively represented, right? If you look at the lawsuit that we filed, we have 5 plaintiffs. Those are the named plaintiffs, the proposed class representatives that we believe could act on behalf of the entire class. But there are a lot of people who have not signed any paperwork and probably will never sign any paperwork, and they're just going to sit at their home. What happens is first you get a preliminary approval with the court saying, hey, we've reached a resolution. We think it's fair for XYZ reasons. Okay, well, just because you get it preliminarily approved doesn't mean that it's over. You then take the preliminary approval and you send out a notice to all of the potential affected members. So you get a letter in the mail or an email, and it says, "Hey, you may have been affected. You may be a class member that qualifies for this potential settlement. Reach out and give us your information, and depending on your information, we'll tell you how much you qualify for." Now, depending on the class action or depending on the case, it's different. Some cases have the same harm to everybody, meaning if everybody got scammed out of $3.25, no matter whether you're the big spender or small spender or whatever, then the payments are uniform across the board. In other situations, you have tiers where if a creator can show that they have lost millions of dollars, well, they may get more than somebody who lost $100, right? So it's just too early to tell. But yeah, I mean that's
What?
how it will work if we're able to get class certification. If we're able to prevail in getting a settlement, then notice would go out from that. And by the way, this is another great thing about class actions. If you are unhappy with your settlement, you can opt out of the class. You can say, "Hey Tom, you're offering me $100, but I think I deserve $500. You are free to tell the court, hey court, don't include me in this settlement. I don't want to waive my rights to sue. I'm going to hire my own lawyer and sue just for my case." Now, again, is
And
that economically practicable for the smaller cases? Probably not. But there are people who opt out of class settlements to pursue larger individual claims if they have it. But this case is so early in the context of Honey,
mhm.
we don't know, and it would be guessing. But if I told you how something was going to happen, but there is a wide range of options.
Right, and there are processes in how you determine who gets what in a class, right?
Sure.
Like you talked about data breach cases. A lot of times they'll pay for the monitoring, the credit monitoring system, and you can get it for up to 3 years, but you got to actually opt in and sign up for it before you can get that money. Or, if you can show that somebody tried to steal your identity and you had to pay an accountant to fix your tax returns and whatever, you can get that reimbursement and you can like submit
Right.
receipts and things like that to a fund. I was involved in one kind of loosely that a theme park was overcharging everybody that had their yearly pass, and you just had to show I had a pass from 2017 to 2020 or just 2 years or whatever, and you get
Right.
X amount of dollars per year as you had the pass.
Right.
So there are ways to figure out who gets what, but not everybody necessarily gets every penny that they deserve. And that comes into the analysis of whether or not you want to opt out or not. But let's say it's $10 million that they create a fund and
Yep.
somebody has $10 million in damages. Like you said, they can opt out. But if there's either not enough money or you're never going to go get that, if this class is getting 10 million, maybe they get 1 million because there's such a huge chunk of the amount of money. And so there are equations and ways they figure out. But usually if you lose more, you take home more out of the settlement. As plaintiffs lawyers, we try to make people as close to whole as we can, but it doesn't always get to, the full amount that somebody deserves. But it's not everybody gets the same amount. You will come up with some kind of way at the end to get people compensated with respect and proportionally to.
In the most lawyer answer ever, without saying definitely yes, most likely in this case, because of the way that I perceive the level of harm, because it could be, you could have a small creator or a big creator. It is very likely, if this case is able to be class certified and if there is a resolution, then yes, there would probably be a scale, subject to me not being able to definitively give you an answer,
Of course.
because you know how it works. It depends.
Sure. No, 100%. I just want, because this is probably the first class action type of law school a case that we've talked about on this channel. So I want people to kind of understand. And I know they've had a lot of questions about, and I've seen questions just on the internet like, well, how does this work now that they all get in a class together? Why would a huge creator want to do that with a small creator? Or how do they even get a small creator, something? And just kind of explaining the thought process of how you go through it, the benefits of having a class together. And I also think, like, from my perspective, you're putting together, before you said it was kind of just you and a staff, not just a staff, but the staff probably doing most of the work and you. And then now you have 10 plus lawyers. So you're a much bigger firm. So you have these class actions, you have more lawyers. Now you have, other firms joining you, and you get a lot of momentum and a lot of leverage behind coming together as a class, which, again, not to really equate this with the P. Diddy, Jay-Z thing, but the more people that come out and say something happened to them, the more people you can show were harmed, the more leverage that comes across. And from your perspective, the more creators you have are creating it as a class action lawsuit also gives you a wider net for discovery of what you can actually look at in their systems versus if you just had one person and something that was going to apply to one person.
That's right. That's it. Yes.
And so why don't you talk about kind of your mind as an attorney that handles these kinds of cases? What benefits do you have when something becomes a class action lawsuit versus when it's just a single plaintiff?
Well, again, I think the number one factor is the ability for plaintiffs or class members to bring legal action. Because again, I think if you didn't have a class action vehicle available to people, what you would have is an infinite number of companies that would have scams that were significant in the aggregate to them, to their bottom line, but insignificant enough that nobody could realistically bring legal action. And you'd be nickeled and dimed to death. So to me, that is first and foremost the most important vehicle. And I think that's appropriate here in this case. I mean, how many thousand subscriber creators are there compared to the 10 million subscriber creators? There's a whole lot more thousand subscriber creators. Even I remember it took me forever to break 1,000 subscribers. I mean, maybe 200 videos. That's a grind.
Sure.
There are, without a class action vehicle, I believe those creators would never have a prayer of being represented. And so it first and foremost, it just allows everybody who is potentially damaged in a scheme to come forward and fight for their rights.
Yeah, and I think it's cool kind of how class actions work too, is sometimes it's hard to find the people that could potentially be affected. Sometimes it's easier, and it happens between you and Devin from Legal Eagle and some of these people that are going to be talking about the case that are going to have a lot of eyes on them, and some even, other creators outside the legal world. They're going to be able to see, was I affected, be able to reach out to, are you soliciting, maybe the wrong word, but are you looking for people that might have been affected by this? Do you have like an email, or should we put 1-800, your 1-800 number on that white screen behind you for somebody to call? Is there a way they can seriously reach out to you though, if they think they were affected?
Yeah, we have a web domain, honeylawsuit.com. Devin actually put it up, but it effectively goes to the same place.
So honeylawsuit.com. We'll put it in the description of the video too.
Honeylawsuit.com. We don't need anybody right now. We have more than enough people who are willing to participate. And again, with the class vehicle that we are seeking, we don't need anybody at this time. But with respect to receiving a notification when the time comes, or if a class vehicle is not granted and you have to go through an individual case, then we can. It will be good for us to have that information. But
so basically,
honeylawsuit.com.
So honeylawsuit.com. So basically, if in these situations, another thing with class action lawsuits is if only 3 or 4 people this happened to, you can't get into the class vehicle. So that's also important too. And something you kind of go ahead.
Correct. There are a list of factors that a court will weigh when they decide whether or not something can be a class. One of those factors is numerosity. So if there were only 4 people affected, the court would say, you could just sign up each four individual plaintiff and have them bring an individual case. Or if it's not an individual case, they can be individual plaintiffs on one lawsuit, and we could just save a lot of time. This class vehicle is not appropriate. So here, we don't exactly know the number we are going to suggest to the court of how many people are affected yet, but it is hundreds of thousands, probably.
Wow.
So.
And so another factor is that they have to be similar, which is why the consumers are not going to be in with the creators. They were affected differently. So if you did do something with the consumers, it would be a separate class potentially.
Correct. Similarity, typicality. Here we believe that the harm is caused by the affirmative switching of the cookie link, of the affiliate link, or the coupon link. So that is a similar tort. We believe it's a tort. It's a similar action that is transpiring across a number of potential class members. Again, this is all subject to court approval, and I'm sure very articulate arguments from defense counsel as to why we shouldn't get a class. But yeah, at a high level.
That's a good point to point out too. Just because you say it's a class, just because we're talking about it like it's a class action lawsuit,
exactly
you
right.
got to go argue that, and the court's got to make a decision. Is it numerous enough? Are they similar enough? Is this something that we should actually make a class? And if they say no, then you're at square one, determining what are we going to do individually speaking. And
absolutely.
At this point, that's also another good point that you made earlier with the smaller creator, and really focusing on the smaller creator and how class actions are good for them. Because guess what? If it's not a class, the guy with the 10 million or the gal with the 10 million subscribers, they're going to be able to get a lawyer. They're going to be able to individually go after Honey and whoever else they think is a wrongdoer in this and go get their damages. And all of the smaller creators are just going to be out there in the wind emailing honeylawsuit.com. And it's going to be like, these cases cost so much money that, your damages, you're going to end up in the negative at the end of the case if you were to go forward with your case. I don't think that's something that you want to do. Fighting for the principle of it for some of these cases just ends up putting people in a big hole. You get a piece of paper at the end that's not worth what you've spent on it. And, that's an issue as well, which is why these classes can protect the little guy or the little gal in these situations, or the smaller creators specifically talking here. So that's going to be interesting and something that we'll have to kind of keep up with on when those arguments come down the pipe. And then if it is granted to be a class cert, whatever they call it, that's something that'll kind of be a next big step for you guys. But the honeylawsuit.com thing and people going on there and signing up, if you are successful in this case, and you said when the time comes for us to send out the letters to let people know, if you go to this website, I assume, and I'm asking you, if you go to this website, they're on a list that in the future, if you're successful, that will be their opportunity to collect out of whatever the fund is that you negotiate with Honey and PayPal if you are successful.
That will establish a direct line of communication.
There you go.
Not to say that there wouldn't be other forms of communication, like public announcements, but if you submit your information to your website, we now have it, and then once we have it, we can.
And there's no guarantee just because they sign up, they're going to get money, right? I mean, you're going to have to go through it.
Correct. And technically, right now, we're not. If you enter your info into our website, we are not signing people. We already have enough. We have our clients. We're not taking these on an individual basis right now. This just simply is a way to establish communication with us at this time, subject to change, right? Like if for whatever reason class certification wasn't granted, then we'd probably send a blast email to everybody who has entered the form, and a lot of people have entered the form, and we'd say, hey, class vehicle is not appropriate. We can review your individual claim, set up a consultation with our team member or whatever.
And I'm seeing this as a benefit to the content creators that might be watching this more than it is a benefit to you, because from their perspective, they go to honeylawsuit.com, they put in their information, they have an opportunity to talk to you guys at some point, even if it's in the future. That does not lock them in. Just because you go to honeylawsuit.com doesn't mean Tom has to be your lawyer. Doesn't lock you in at all. It potentially just gives you more information. It gives you an opportunity. It gives you an option in the future. I don't get anything from this either. Like just to make it clear, like just because you go to this website does not lock you into anything. It only provides an opportunity that may or may not come in the future. That's basically all I see.
It establishes a direct line of communication.
Right.
And then if there's a time where you need to sign something or be represented formally or whatever, then you would know at that time. There's no trickery by just submitting your information.
Right. All right. I mean, that was a lot. And from my perspective, I don't do class action lawsuits. They can be incredibly complex. I enjoy looking into them and trying to break them down on a simplistic level that we're able to talk about kind of some of the big steps that have to happen, what potentially could be the forks in the road that could make you successful or make you lose the case or change course of what you want to do. Is there anything else you think is kind of important that we need to discuss from the lawsuit, from the process that we haven't already talked about?
No, just to reiterate, this is a case at the very beginning. It's not an easy case by any means, but it's a case that we believe in. As a content creator myself, Devin being a content creator too, having a team of lawyers who understand what it is to be a content creator because they're around content creators all the time. We just felt very strongly when this information came out that we were uniquely qualified to take this on, and we're happy that we have. We can't guarantee a result, but win or lose, it's a fight that we believe in. So,
yeah, and we talk about a lot how, lawyers become experts, especially in some of our criminal cases that are, some white collar cases or whatever it may be. You become experts in different fields that are not law. And this would be one of those fields that you guys are kind of already experts on that you will become even more of an expert on. Like I do some of these things and I have relationships with some of these companies and I would not call myself an expert on them personally. So I'm glad that there are people that really are digging into this. I'm sure you'll know more about this than you ever cared to know by the end of this case. But I do think it's really an interesting thing. And just because something bad happened or potentially creators lost money or there is a wrong still doesn't mean, Tom and his team are going to go win. It doesn't mean they're going to be successful. It doesn't mean it's going to be a class. So two things can be true, but I would agree with you. I don't think not many class actions are easy slam dunk cases, especially when you come down to how much money is going to be available for the class, right? Even if you go win and the court's like, no, that's too much, or they're not going to give you enough, or whatever it may be, it's hard to fight these things all the way till the end to get the full amount of justice and the full amount of damages that could potentially have happened from the harms caused by someone's wrongdoing like this. So I'm interested to see how you guys play this and how this one rolls out. So we'll have to keep in touch, see how it goes. I'll be following it along on your channel. We'll link your channels and all of that in the description as well for anybody that wants to follow Tom as well. I appreciate you taking an hour today to hang out with me, man.
Yeah, Peter, thanks for having me.
All right. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.